Good morning, Your Honors. May it please the court. My name is David Luck. I'm from the firm of Lewis, Brisbois, Bisgard & Smith, and along with my colleague Vincent Alexander, I represent the appellant in this matter, Venus Concepts USA Incorporated. Your Honors, I'd like to begin by respectfully requesting that I be able to reserve 3 minutes for rebuttal.
Okay.
And with that, Your Honors, I'll get into the arguments. There's really 3 principal points to make here, Your Honors. The first one is relatively easy, and it's that de novo review applies here. When Your Honors are interpreting whether a mandatory forum selection clause applies to a claim or causes of action or a case law that you have provided is clear that the standard of review is de novo. Just as an example, I would cite, Your Honors, to Agile Assurance versus Palmer, which is a 2014 decision from this case. It's at 147 Southern 3rd, 1017. Not going to belabor that point. It's de novo review. Next point, Your Honor, and I'm really not sure how we got here. This should have been very simple and a clear-cut situation. 3 of the 4 claims that are involved here are brought by the entity plaintiff, which even according to opposing counsel is a party to a contract that contains a mandatory forum selection clause. They got around that by convincing a trial court to ignore Florida law. Specifically, they cited cases that have nothing to do with mandatory forum selection clauses. They instead cited cases that deal with general venue statutes that do not involve mandatory forum selection clauses. Specifically,
Mr. Luck, let me interrupt you right there, because I'm not entirely sure how we got here either. And I'm wondering specifically if there's, if you can answer this, why didn't you just move to sever the first 3 counts and transfer?
Well, Your Honor, we've taken the position that you can do that in the alternative, but it's our position that the 4th count, the negligence count, is intertwined with the 3 remaining 3 initial counts, and that's supported not by necessarily our arguments, but by how plaintiffs pled their cause of action in this case. If Your Honors look at the complaint, the actual complaint in this matter, which is at pages 6 through 15 of our appendix, you flip to paragraph 10. This is plaintiff's characterization of this case. This action arises from Venus's misrepresentations made in connection with its sale of defective medical aesthetic equipment to Ultimate Image, which caused personal injury to Dr. Besnoff, who is the sole principal and officer of this closely held entity plaintiff corporation. So that paragraph indicates that all 4 of the causes of action here relate to Venus's misrepresentations and the breach of this contract. And they include in that the personal injury to Dr. Besnoff. Then, Your Honors, if you look at the general allegations, which are paragraphs 1 through 53 of the complaint, 2/3 of those allegations relate to the contract, the purchase agreement, and whether we adhere to the purchase agreement and the representations that were made in association with that agreement. You then look at count 4, which is negligence, which is on page 14 and 15 of our appendix. The first paragraph of that count is paragraph 70. And it says, Dr. Besnoff realleges and incorporates by reference the allegations of paragraphs 1 through 53. So they took all of the contract allegations and said that their negligence claim depends upon the purchase agreement, the misrepresentations, and the breach of that agreement. That's their pleading. Has nothing to do with what we did.
So you're saying that we can reach the result that you want simply by looking at the allegations of the complaint, and we don't have to get to the issue of whether Dr. Besnoff was a non-signatory?
Well, Your Honor, those issues are actually.
Let me
Sure.
sever that point. Is that what you're saying from the allegations and the reincorporation of those allegations? That
No.
we can simply look to the complaint?
No, Your Honor, that's not what I'm saying. What I'm saying is those 2 points are related. The reason for that is the trial court also overlooked, there's a substantial body of federal case law, which cases like Deloitte from the 5th District and cases like East Coast Karate's case from the 4th District have adopted for purposes of Florida. It's called the closely related doctrine.
And our court has not.
I have not seen a reported decision from your court addressing this. However, every DCA that I'm aware of
I don't know
to
about
have
the
addressed
first.
this issue.
I don't know if I saw a case from the first.
Yeah, I was going to say every DCA that I'm aware of to have addressed this issue has agreed with the closely related doctrine, which makes sense because the forum selection clause jurisprudence in Florida, which was originally articulated by Justice Barquette, in Manrique versus Fabry in 1986 adopts the federal US Supreme Court Bremen standard for enforcement of forum selection clauses. So the reason I mention this, Your Honor, and I won't go through all of these cases, but I want Your Honors to be aware of in specific reference to what I believe is the most recent case in this area, and it's from the 3rd District Court of Appeal. And the title of that case is West Bay Plaza Condominium Association versus Sika Corporation. That's at 338 Southern 3rd 32. It's a 2022, I believe, March 3rd, 2022, 3rd District decision. And in that case, it explains that Florida's courts, the DCAs, and by the way, under Pardo, regardless of whether Your Honors have addressed it or the 1st District has addressed it, under Pardo and system components, this trial court was bound by the law in Florida from the other DCAs to have addressed this issue, which is that the closely related doctrine applies in Florida. This case holds, and this is a quotation from the case, and it starts with where the resolution of the plaintiff's claims requires reference to the agreement with the forum selection clause, and the claims brought specifically reference the agreement, there is a significant relationship and a clear nexus between the agreement and the claims, and the forum selection clause therefore applies. The same case law from federal courts and also Florida courts explains, and this goes back to Lipcon from the 11th Circuit, and then numerous other federal decisions that we cited, explains that this doctrine, the closely related doctrine, is a flexible, common sense, totality-based standard.
But I don't need the contract to resolve his claim.
I disagree, Your Honor. Again,
He apparently uses the machine and scalds his head or whatever it is. I mean, that's a pure PI case. I don't need to relate it to the terms of the contract, do I?
no, I disagree, Your Honor. Again, they chose how to plead their claim. Their negligence claim incorporates all of the contract allegations. Moreover, paragraph 15 of the purchase agreement specifies the terms regarding in-service training regarding this equipment. That is what was going on here when Dr. Besnell volunteered himself to be the 4th patient. That was the in-service training under the contract. And again, if you go back to paragraphs 1 through 53 of the complaint, which they make central to their negligence cause of action, they plead that that training service with supervision from an agent of Venus is what caused his alleged personal injury regarding the hair
If
follicle.
the doctor had decided to go out on the street, grab the first person he sees to come on in to be a guinea pig, and that person suffers personal injury, clearly it seems to me that person would have been able to bring a PI case and not have to do anything as it relates to the contract.
That is true, Your Honor. The difference there again is, if you look at the closely related doctrine cases, they say that this is a flexible, common sense, totality-based test. Dr. Besnell is not a stranger off the street. He's not a random third-party personal injury plaintiff. He is the sole officer and member of a single-member Florida LLC that he created to run his medical practice that he used to buy this equipment and for which he signed the agreement. Now, I understand that they say, well, here, look, here's some cases.
I'm sorry, you said earlier he was a 4th person?
I believe that's correct, Your Honor.
Who the other 3?
The other 3, I believe, were patients, and there are no claims associated with them bringing the claims themselves.
Okay, so
But
they're patients, they're the people who come in off the sidewalk in my hypo.
correct.
Okay.
So if they brought a lawsuit, they would obviously not be bound by a forum selection clause. But
Is his claim for his personal injuries, is it addressed in the agreement?
it's not addressed in the agreement, Your Honor. But what he does, again, is he takes all of his allegations regarding.
Well, no. I guess my question is the agreement references like third-party claims or injuries from other.
I don't believe that it does, Your Honor. However, what he does
Well,
is
you may want to look at some of the provisions. I mean, they talk about whether or not Venus is going to hold harmless, or excuse me, if Ultimate is going to hold harmless from any personal injuries.
there are certainly indemnification provisions.
Yes.
However, I don't believe that there's a provision that specifically references Dr. Besnell's
No,
individual claim.
I would agree with you.
Right.
Let me ask you this. So if we do not hold that the evidence here met the closely related test, then could we and if we agree that the form selection clause should stand, then can't we just simply dismiss as to ultimate?
Yes, absolutely, Your Honor. And that was going to be one of my points as well. So this starts with a case that plaintiffs cite. It's called Management Computer Controls versus Charles Perry Construction. It's a first district decision from 1999. Very similar to our case in terms of the claims that are pled. You have 4 counts. First count is breach of contract. Second count is negligent misrepresentation. Third count is breach of implied warranty. Those are the same 3 claims that the entity plaintiff has brought here. And then there's a third claim, which the first holds is, as a matter of public policy, not subject to a form selection clause, which is a FDUCPA claim. There's a DCA split on that issue, and I don't need to go there for purposes of today. But what that shows is they held that the 3 initial counts had to go to Shelby County, Tennessee, under a mandatory form selection clause. They didn't say, oh, well, there's general venue case law under those general venue cases that this trial court cited that have nothing to do with mandatory form selection clauses. So long as the plaintiff brings 1 claim that's subject to statutory venue, they can then bootstrap on 3 other claims that are subject to a mandatory form selection clause and ignore 35 plus years of Florida precedent requiring enforcement of mandatory form selection clauses.
And I did not seem to see a case, but was there a case that, I mean, there were definitely cases that talked about multiple claims,
Yes.
but not multiple parties as plaintiffs.
I'm not sure if any of them deal with multiple parties as plaintiffs, but
Other than the maybe the non-signatory cases.
But look at it this way, Your Honor. Their only argument is Dr. Besnov is an individual, and the trial court, which never even considered the closely related doctrine, found that he was not a signatory and therefore he wasn't bound. And then somehow we jump from that conclusion to let's throw out the contract as to the entity with the form selection clause. There is not a single case in Florida or federal court that I have ever seen that allows that. And there are multiple cases, regardless of whether it's 2 plaintiffs or 1 plaintiff, that hold that even a single plaintiff, if you bring multiple causes of action, 3 or 4 or 5 of which are subject to a mandatory form selection clause, and you bring 1 or 2 or 3 that are not, you're still bound by your form selection clause. And those causes of action go to wherever the contract specifies they are to be litigated. Your Honors, that brings me to another case I wanted to mention. It's another case that they also cite, Turnkey Projects versus Gawad, 2016 5th District Court of Appeal. In that case, the court required splitting of causes of action, required contract and inducement claims to go to Nigeria, so much further away than Broward County, and allowed conversion and fraud claims regarding an escrow account that were unrelated to the contract could remain in Florida. Again, I'll repeat this because I think it bears emphasis. They have not cited a single case that allows you to ignore a mandatory form selection clause regarding entities that are parties to that contract. Their only argument that somehow morphed into throughout the entire contract here is that Dr. Besnov is an individual, despite the fact this is a closely held entity and he signed the agreement on behalf of that entity and he incorporated all the contract allegations into his negligence count. He's not responsible, so therefore no one is subject to the form selection clause.
And Mr. Luck, let me just clarify, you did ask at some point for that alternative relief?
In our briefing here, Your Honor, we specified that you could at most sever, at a minimum sever is what I should say.
Okay, because I was
In our
looking
reply brief.
specifically at your prayer for relief here, and it
Yeah.
does say that it's an all or nothing.
In our reply brief, we specifically mentioned that at most their argument would lead to severance of the individual plaintiff's claim. It would not result in the entire lawsuit having to stay in Pinellas County when we have a mandatory form selection clause regarding Broward County. Last point that I want to make, Your Honors, before distinguishing their cases incomplete, and I'll make this quick because I'm probably running low on time, but I want to point out that Appendix 77, which is the relevant page of the trial court's order, the only cases that are cited are as follows, none of which have anything to do with a mandatory form selection clause. In fact, and this goes back to something you mentioned, Judge Smith, you wanted to know about whether there was a case involving a situation where you had 2 plaintiffs. This case doesn't involve 2 plaintiffs, but it is a case that they cite for the proposition that when you have 2 plaintiffs, you can throw out a form selection clause, and it doesn't stand for that proposition. It's called Intercapital Fund versus Isclair. This was the primary case that the trial court and plaintiff cited below. It's a 1996 4th District decision. It's at 683 Southern Second 530, and the relevant portion
And
of
that
the
was
opinion.
multiple claims, that wasn't multiple.
It was
claims.
multiple claims, and that's at page 532. That case, they cite for the proposition that when you have multiple claims, any one of which has proper statutory venue, then venue is proper under a general venue statute in the county. However, that opinion specifically says, we recognize Bremen, we recognize Manreed versus Fabre, we recognize that where there's a mandatory forum selection clause, general venue statutes go by the wayside and you have to enforce the mandatory forum selection clause. However, in this case, we don't have a mandatory forum selection clause. That's their central case that they rely on. Doesn't involve the mandatory forum selection clause, and says that had that case involved one, they would have been required to enforce it under Manreed versus Fabre, 1986 Florida Supreme Court decision, and the United States Supreme Court's 1972 decision in Brennan. Next case that the trial court cited, and they cited below, Davis versus Dempsey, 1977 third district case that predates Manreed versus Fabre by nearly a decade. Has nothing to do with a mandatory forum selection clause. It deals with a general venue statute and the proper place of payment under a contract. Because under general venue statutes, you can bring a breach of contract action in a county where the contract is breached, which is often defined as where payment was required. Case has nothing to do with mandatory forum selection clauses. Same thing regarding Oliver versus Severance, which is another case that plaintiffs in the trial court cited below. No forum selection clause in that case. It's a first district 1989 decision, 542 Southern 2nd 408. It's a general venue case, involves an industrial trucking accident and failure to procure adequate insurance. Has nothing to do with the mandatory forum selection clause. Your Honors, I'm going to wrap up by just pointing out plaintiffs also cite a number of cases that deal with enforcing arbitration provisions against non-signatories. That is expressly subject to a different test, because arbitration provisions take away a litigant's ability to have access to courts. There is nothing of the sort involved regarding a mandatory forum selection clause that requires litigation in another Florida county. None of those cases dealing with arbitration provisions have anything to do with the analysis at issue in this case.
Good timing.
Thank you, Your Honors. I appreciate it. If that's my last bit, I will sit down. If not, I did have one more case I wanted to mention, but
Save it for your rebuttal.
understood. Thank you, Your Honors.
Ms. Corrigan, is that correct?
Yes, may it please the court. I'm Jody Corrigan from Rochester Claimants Bar, and I'm here on behalf of the attorneys, Ultimate Image, and Dr. Todd Besnoff. I wanted to answer the questions that you raised. First, you are correct. We do not need to refer to the contract at all to resolve Dr. Besnoff's personal injury claims. Personal injury claims are not addressed in the purchase agreement. And I am aware we did not cite a specific case that deals with a specific problem like we have in this case, because I was unable to find one. So,
Well, let me tell you my concern here is that, well, anytime there's a mandatory forum selection clause, someone can defeat it by simply adding another party and adding another claim and circumventing the whole purpose of the contract and the terms. So, and these are completely separate claims.
right, they are completely separate claims. I think that what we need to do though for this case, is that possible that anybody could thwart the case?
Well, it looks
Yeah.
like that's what happened here.
But it's not. If you look at the forum selection clause itself, it specifically, maybe this is a drafting error on their part, Venus drafted the contract. It specifically states that the customer consents to jurisdiction. The contract defines the customer, and it is not Dr. Besnoff.
Well, he signs it as,
He
I
does
mean,
sign-
it's kind of interesting you say that because the customer on page 1 says the company, but then the customer on page, unless this would be page 4, says customer Todd Besnoff. So I mean, I understand the intent was obviously for Ultimate, but Dr. Besnoff actually signs as the customer on
Well,
page 4.
He is specifically identified though as a contact person.
I think it says customer if you look at it on page 4, record page 19.
All right, and
I have no doubt that that was probably an error, but that's what the contract says.
okay. The contract provision also, and we're not trying to say that there is no such thing as a mandatory forum selection clause. Obviously, there are mandatory forum selection clauses. And if this was brought without Dr. Besnoff's claim, Ultimate Image might be looking at that, but this specifically says that venue of any action to enforce or relating to the agreement must be brought exclusively in Broward County. Dr. Besnoff's claim is neither. He doesn't rely on any provision of the purchase agreement to pursue a personal injury claim, and it doesn't require any interpretation of the agreement. The forum selection clause itself could have been broader. In the reply brief, Venus argued that the forum selection clause required all claims regarding the business relationship to be litigated in Broward. But that's not what the contract says. It's something that it could have said. It could have extended to principals or officers, but it did not. And then unlike any of the other cases that have been cited in this matter, the purchase agreement specifically limits who is bound by its terms. In paragraph 42, it specifically states nothing in this agreement shall be construed to confer any rights, remedies, obligations, or liabilities on any person other than the parties hereto or their respective successors and assigns. This is where the contract language itself should end the inquiry right here. It's specifically,
Let me
yes,
interrupt you for a moment. I'm not so sure now that the contract is not an issue even as to his PI claims, because as I understood Mr. Luck's argument, these services, this training is being provided pursuant to the contract. The doctor, I take it, is going to be the primary user of this device. And wouldn't it be the case that some discussion is going to arise about the contract terms and the teaching or training responsibilities?
the training issue is a little bit complex because the contract does require training. The problem is that's actually a factual issue. It's not alleged in the complaint that it was part of the training, and there was no affidavit or anything filed with the motion to dismiss to raise that argument. So it's something we're kind of dealing with in this.
Well, it's part of it, it's attached to the complaint, it's part of it, it's there, we know what
The contract does
obligation-
require training,
Yeah.
but nothing specifically says this was during the training session. So I can't definitively answer that, but what I can say is the Bahamas sales case that we have cited simply says that even if you've got a situation where but for the contract, one of the claims would have never arisen, that's not enough. That's not enough to establish the close relationship that would require applicability of a mandatory forum selection clause to a non-signatory. And in that case, it specifically went through when a claim relates to the dispute. And the court, this is a 11th Circuit case, Bahamas Sales Associates versus Buyers. The court came out and said that the fact that a dispute could not have arisen but for an agreement does not mean that the dispute necessarily, quote, relates to the agreement. Related to marks a boundary indicating some direct relationship. Requiring a direct relationship between the claim and the contract is necessary. Because if relate to was taken to extend to the furthest stretch of indeterminacy, it would have no limiting purpose whatsoever, really universally, because relations stop nowhere. So basically, that case came out and said that when you're having to determine the scope of a contract and what is required and what is not, you have to look back to the contract language. And that's where, in this case, the contract language is specifically limited to the parties. The reason we argue that the venue statutes were the applicable rule is because that's how the venue statutes work. And we cited the intercapital funding case, not because of a forum selection clause. We know it doesn't have one.
Any cases deal with multiple parties?
Oh, no, we have not. I have not found a case that really mirrors this situation. Even in the cases that involve tort claims and contract claims, I've not come across a case that involved a personal injury claim like this one. And candidly, this could have been avoided if perhaps they had moved to dismiss earlier or sever the claims, but that didn't happen. It wasn't until the reply brief that they suggested severing the claims. And candidly, looking at the severance cases, there is a Zuckerman case, Zuckerman Vernon Corp. It's a third DCA case, 303 Southern 2nd 391. That basically said that the severance rules make no provision for transferring one or more claims or issues to a court in another jurisdiction. So I'm not entirely sure that that could have been done that way anyway, if they had moved to sever. But under the venue statutes themselves.
Let me ask you the same question that I asked Mr. Luck is could the court here grant as to find error as to the denial of the motion to dismiss as to only ultimate.
And leave the other claim that Dr. Besnell has pending in
Yeah,
Pinellas
because the
County.
motion to dismiss was as to the whole
Right,
complaint. But if we apply it to simply the ultimate claim because of the forum selection clause, what prohibits us from doing that?
the fact that it was never asked for until their reply brief.
But you have three options.
Right,
Everything's gonna be in Pinellas, everything's gonna be in Broward, or you're gonna split it. Which doesn't seem like a particularly efficient way to run a train,
no, it does not.
but I guess perhaps that's fine.
Well, we believe that based on the language of the agreement, that should not happen, because this is not, Dr. Besnoff's claim is not subject to the agreement. So for him, candidly, I'm not sure. I'm not sure whether that would solve the problem or not. We had cited in our answer brief some other cases that Bahamas sales agreement where the court rejected the applicability of a form selection clause to bind a non-signatory because the clause itself specifically applied to obligors and the non-signatory was not an obligor. Same thing in the Data Line Corporation case where the contract stated that the customer submits to jurisdiction and venue, and yet, so the court determined that only the customer was restricted, and in that case, the plaintiff was not a customer, so it was not restricted. And if the form selection clause itself can be given more than one interpretation, it should be decided against Venus. The turnkey projects case that council just referenced, that is also something that we cited. Basically, that one is a Florida case that set forth the three situations where a non-signatory could be bound by a contractual form selection clause. Those are the three situations: a close relationship, the non-signatory's interests are derivative of the signatory's interests, and the claims involving the non-signatories arise directly out of the agreement. The only one that's even an issue here would be the close relationship. And factually, in turnkey products, the court ruled the form selection clause did not bind the non-signatories because the claims against them were tort-based and not contract-based, and they determined that the tort claims did not arise directly out of the contracts. The last case I wanted to mention is the Leatherwood case, a 4th district case, where the president of the corporation was deemed not to be bound by a form selection clause in a contract between his corporation and the defendant for 3 reasons. The president was not a signatory to the contract. The president's cause of action was in tort. It was claimed for credit slander and fraud and not in contract. And finally, the president's claim did not involve matters relating to the interpretation, performance, or breach of contract. And that seems to be the situation that we have here. They're trying to bind Dr. Besnoff to a form selection clause to which he is not a party. And I think the trial court correctly walked the line. There is no specific case law that truly answers this question definitively. The venue statutes permit, if there is a venue proper in more than one county, that the plaintiff gets to choose, and that's what happened here. Oh, I also want to mention the West Bay Plaza condominium case that council referred to. In that case, the court determined the condominium association was bound by the form selection clause because its sole claim was for breach of a warranty, and a warranty itself is the document that contains the form selection clause. No further questions?
Thank you, Cory.
Thank you.
Good luck, you have your 3 minutes.
Understood, Your Honor. I'll try to be as efficient as possible. Start with the low-hanging fruit. I'm really perplexed as to where we are here. None of what opposing counsel just said is remotely the law in Florida between 2 entities that have a mandatory forum selection clause. I want to refer Your Honors back to the East Coast Karate case, which is a 4th district decision. It holds, and it refers back to the 1986 5th district decision on this point. When you have a contractual waiver of venue privileges, the reform selection clause, then the convenience factors under Chapter 47, as well as the other statutory grounds for venue set out in Chapter 47, go bye-bye. They're gone. You can't cite to a general venue statute and say, oh yeah, we have a contract here between 2 entities and there's a mandatory form selection clause. Sorry, Justice Barquette. Sorry, Manrique versus Fabry, which has been around for 35 years. We're not going to enforce the form selection clause between 2 entities. That is just nonsense. It's nonsense. It makes no sense. The two statutes that they cited are 47.011 and 47.0154 statutes, general venue statutes. They cannot overcome a mandatory forum selection clause between the two parties to the agreement. Distinguishing their case law, Your Honor, I want to start first with this proposition that somehow a tort claim isn't subject to the analysis under either the forum selection clause or the closely related doctrine. That also is incorrect. I would refer Your Honors to Ward Vacations versus Brooker, 2001 third district decision. The court there specifically says that forum selection clauses apply to tort claims. This is at 799 Southern 2nd 410. Relevant pin site is pages 412 through 413. The analysis is whether the tort claim involves performance of the contract or interpretation of the contract. Again, they're the master of their complaint. I heard nothing from opposing counsel regarding the fact that they chose to incorporate all of the contract allegations into their negligence claim. Next case.
But doesn't it make a difference if the negligence claim is a product liability claim as opposed to say, operator error or something like that, failure to train the operator who was performing the demonstration. And so isn't that a meaningful distinction?
That's actually interesting, Your Honor, because we're not sure exactly what the negligence claim is because they failed to allege an actual product defect. So it's pled generally enough that I'm not exactly sure. That was one of the bases for our substantive motion to dismiss. We had a motion to dismiss for forum, improper venue, and then we also had a motion to dismiss for failure to state a cause of action. And that was one of our arguments. So again, another case they cite on this tort versus contract distinction is a Ninth Circuit federal case, Minetti Farrow versus Gucci America. That case also says forum selection clause can apply to tort claims. The question is, what did they plead? Did they include reference to the contract? Does their claim depend upon the same facts as the contract claim? Here, the answer is yes. Really fast.